Good afternoon, everyone. It's Mark Gracie here. Just about to kick off the Introduction to General Data Protection Regulation webinar. Hopefully you can see the screen, which will be is a title screen with a big blue square in the middle. Just to let you know that I'm recording this session, and I'll share a link to the recording afterwards. So if you want to revisit anything that was covered, then you can do so. I also tend to share a copy of the slides as well in case they're of any use. If you've got any questions, we'll save those to the end, and there's a questions section of your control panel which is where you can put your questions in, so feel free to type those as we go through and I'll pick them up at the end. Otherwise we can do a quick Q&A at the end. Expecting to talk for about 30 to 40 minutes, so there should be plenty of time for questions. So thank you very much for joining. My name's Mark Gracie. I run a consultancy called Flavorfied Digital and an online service called Digital Compliance Hub, and I'll just tell you a bit more about those towards the end. But basically, I just wanted to give some backgrounds to myself and why I know about data protection and why I'm talking about GDPR. So I have a background in the internet industry since the mid-90s and have a 15 to 20-year career in a regulatory manager role dealing with internal compliance with regulation, mainly in internet and telecoms, and also external stakeholder influencing, so trying to convince regulators and the government and working with government and industry partners to make sure that the approach to regulation works well for business. And in 1998, when the Data Protection Act became law in the UK, I became a data protection officer for an internet business that had data everywhere. So I understand data protection, I understand the law. My background, as I say, is in internet and regulation particularly. And also, I think of myself as a bit of a techie. I've got a computer science degree, but I've also got a master's degree in computer and communications law as well to back up that those regulatory credentials that I've built up over my career. But anyway, that's enough about me. I'll talk a bit more about some of the services and how I can help you towards the end of the session. But we're here to talk about GDPR, the General Data Protection Regulation, and this is an introduction to GDPR. We'll be talking about some of the basics of data protection, talking about what I see as the main 10 changes to General Data Protection Regulation, and what that brings to the UK in May next year, and then look at some of the things that you can do to help yourself get yourself in a position of compliance. So hopefully by the end you should understand what GDPR is all about, whether you need to worry about it, and if you do, some thoughts about what you can do to help yourself meet the compliance needs, or your compliance needs, I should say. First up though, let's just cover the basics of data protection. It's always useful to do that so that we make sure that we're all understanding some of the underlying principles of data protection, because to be honest, there's not much changing in that area, and so you need to understand the basics of data protection to be able to get to grips with what the GDPR changes are. And also I tend to use terminology like processing and data subject, data controller, that kind of thing. And it's worth putting those into context and make sure that everybody understands what I'm talking about. So let's start off by just covering off some of the basics of data protection. And first up, about data protection definitions. There's quite a few definitions in the GDPR, but some of the key ones are there on the screen. So you've got personal data, and that's the data. So basically data protection applies to personal data, and personal data is defined as any information that helps you identify a living individual, either directly or indirectly. So even if you have a piece of data which might in itself not look like personal data and enable you to identify somebody, if you have other data that you can use with that that would identify an individual, then that data too is covered by the regulation as personal data. Now in a business-to-business environment, if you have an individual employee within a business's data, then that too is personal data. So don't think that personal data or even data protection in general is just about consumers or individual citizens. It's actually any data that helps you identify an individual, and that will include business people within businesses. Processing, in terms of data protection, processing covers pretty much everything that you can do and that can happen with data. So it's not just about the use of data for the purposes by which you've collected it, but it's about the storage of it, it's the manipulation, it's the collection, it's the changing, it's the updating, and so on. So every aspect of what you do with the data, the personal data, is referred to as processing, and that's quite an important definition to remember, because it means there's a much wider bunch of things to consider when you think about what you're doing with your data. Now, the data subject is the individual whose data it is that you're processing. The data controller is the organization that's collecting the data subject's personal data and determining how it's going to be used. And a data processor is an organization, typically a third party, that the data controller is using for the processing of that data. So that might be in a sort of typical scenario, if you are collecting email addresses of potential customers, those email addresses will be personal data, and they will reflect upon the data subject. You will be the data controller because you've collected the data, all those email addresses. And if you pass them to a third-party marketing company to send out your email newsletter or your email marketing, then they would be the data processor. So those are some of the key definitions within data protection. Now, in terms of the underpinning rules, then these are called principles. The Data Protection Act talks about 8, which are the 8 that are on screen right now. The GDPR has those 8 in it, but actually talks about 7 data protection principles, and we'll talk about that a bit further into the talk. But essentially, all of these are the underpinning rules of data protection, be that GDPR or Data Protection Act terms. So first up, the processing of data has to be lawful, and we'll talk about what that means in a moment, and it has to be fair and transparent. And that essentially means that the data subject, the person whose data it is that you're going to be using, needs to understand why you're collecting it and what you're going to do with it. So they have to have a full understanding of how their data is going to be used, and it has to be processed in a lawful way. So there has to be a lawful reason for that processing. It must be processed for a specific purpose and only for that purpose. So if you collect data for delivering a service, for example, then it must be clear that that's what you're using the data for. And if you need to use the data for some other purpose, then you need to see what the lawful basis for processing would be in those circumstances. So you must only collect data for a specific purpose, and the data must also be relevant. So you only collect data that you need for that purpose that you're going to be using it for. So if you don't need to know the postal address or your date of birth or the date of birth of the subject, then you shouldn't be asking for it. You also have a duty to make sure that the data is kept up to date and accurate. And there's 2 sides to that. Firstly, if the data subject tells you that their data has changed, you've got an obligation to make sure that the data is changed, so your records are updated. And if you've shared that with any third party, like say a third party marketing company, then you need to be sure that you have updated, told them to update their records as well. And the other side of it is that when it's appropriate to do so, you should, on a reasonably regular opportunity, ask the data subject to just verify that their data is indeed accurate. Retention-wise, you should only keep data for as long as you have a business or a lawful purpose for doing so. So if you don't need the data anymore and you don't need to keep it for any other reason, then you should delete it. And then all processing of data has to be done securely. So if you remember when I said about processing means everything, so from storage to collection and actually using it, all of that needs to be done in a secure way. So that means you need to think about who do you use for storage of your data, how do you share it, where do you store it, what kind of processing you do, and everything like that. So that's as much about your password protection on your computer for accessing your Excel spreadsheet as much as how you share data using email, perhaps, or how you process it in your processes that you use for delivering the service that you've collected the data for in the first place. Now, as I say, those are the 6 core principles and rules. They exist as those 6 in the General Data Protection Regulation, and then underpinning that is a 7th in GDPR terms called accountability, and I'll talk about what that means, but in essence it means, sorry, I'll talk about that in a moment, but in essence it means that everything you do, you are accountable for, and it's up to you to demonstrate that you're compliant. Now the bottom 2, individuals' rights and international transfer, these were Data Protection Act principles, but they are they're not principles as listed in the principles section of the GDPR, but they do exist still in GDPR terms. So firstly, you have individuals' rights. So these are the rights of the data subjects. Probably the most well-known one is the data subject access request right. That gives the individual or the data subject the right to ask you to tell them what data you hold on them, how you use it, and to provide a copy. And there's a number of other rights, and we'll talk about some of the changes that are coming in the individual rights area in a moment. And an international transfer is a set of rules that basically says it's unlawful to transfer data outside the European Economic Area unless the country that you're passing that data to or processing that data in has adequate data protection rules in place, and adequacy of data protection may be that their national laws are adequate, or that there's some other scheme or contractual terms in place to ensure that your data, so the data subject's data, is being processed outside Europe in a lawful way according to European law. Probably the well-known example there is if data is processed in the United States. United States don't have adequate data protection, so they have a thing called Privacy Guard, which is a system that businesses in the US can sign up to that basically say they sign up to European standards of data protection. And unless other protections are in place, you shouldn't allow any processing in the US of European citizens' data unless the company you're using is registered with Privacy Guard. So that's the rules that set the approach to data protection in a general sense. So let's talk about lawfulness of processing, because this is very important. As I said, the first data protection principle is that you must only process data if it's lawful for you to do so. So there's various lawful bases for processing. The one that everybody's talking about, and I'll explain why everybody's talking about it in a moment, is consent. So if a data subject has told you, yes, you can have my data and yes, you can process it in that way, then it's lawful for you to process it for that purpose. But it is important to just say that consent doesn't have to be available. There may be other lawful bases for processing as indicated by this list. So consent shouldn't be the thing that you go to by default. You need to think about carefully which one of these is your lawful basis for processing. So consent is one of them. You will need to collect data, perhaps for delivery of a service or a product that you're selling. So you're entering into a contract with the data subject, and the data you need for the performance of that contract would be your lawful basis for processing. That means you don't need to ask for consent to process the data for the delivery of the service that somebody's taking from you, for example. You may be legally obliged to process data. So, for example, the taxman requires us to keep our tax records for 7 years. We might not need that data for anything else other than for tax purposes, but that tax purpose is the legal obligation that therefore makes that your lawful basis for processing. So if you're required to keep data longer than you have a need to keep it, then it's lawful for you to keep it and process it for that particular purpose for as long as that legal obligation exists. Another example is in employment law. You can be taken to tribunal within 3 months of, or 3 to 6 months of, say, taking some interviews or interviewing candidates. So you're legally allowed to keep that data for the purposes of defending yourself in case somebody was to take you to tribunal. If you have no reason to keep that data after that, then you must destroy it. In some circumstances, typically life and death scenarios, it may be in the interest of the data subject for you to process their data. So, for example, a GP may be concerned about the welfare of a data subject, and therefore it would be lawful for them to pass their details on to the police, for example, to put some protections in place. So if it's in the interest of the data subject, then that's a lawful basis for processing. And If you're a public body, then it may be in the public interest that you process data, maybe for health purposes or something like that. So so that's another thing, but that typically only applies to public bodies. And finally, a very grey area called legitimate interests, where if no other lawful basis for processing exists, but you can prove that there's a legitimate interest for your business, for you to process data in a particular way, then it would be lawful for you to do so, as long as it's not harmful to the rights of the data subject. An example there is, if you're chasing a debt, it would be lawful for you as a legitimate interest in your business to share the data of the person who owes you the monies with a third-party debt collection agency. So you would claim you have legitimate interest in chasing your debts. You clearly wouldn't ask for consent, because you probably wouldn't get it, because if they're not paying your bill, then they wouldn't give you consent either. Therefore, it's lawful for you to process the data in that way. Now, the important thing, certainly from a GDPR point of view, is this accountability thing. And in all of these, it's up for you to decide what's your lawful basis for processing and being able to demonstrate that you can show that you've acted lawfully accordingly. So let's talk about the GDPR, the General Data Protection Regulation, and what I see as the 10 changes that are coming, or the main 10 changes which are coming, and this diagram highlights those 10, and we'll work our way through them. So just to be clear, in case you hadn't realised, General Data Protection Regulation is a European regulation which comes into law in the UK as much as the rest of Europe, but it covers the whole of Europe on the 25th of May 2018. Because it's a European regulation, it applies to the whole of Europe, and that includes the UK, even though we're leaving Europe at some point in the near future. So let's work our way through these 10 changes. So first up is scope. As I said, because it's a regulation, it applies across the whole of Europe, so it affects all member states' laws and replaces all member states' data protection laws that were previously implemented, and that includes replacing the Data Protection Act 1998 in the UK. It also affects any business that is any business, even if they're non-European, delivering services to UK or EU citizens, and if it can be demonstrated that their services are being targeted to European citizens and they're outside the EU, GDPR still applies to them, and in some circumstances they will need to be having a representative domiciled within Europe to deal with any regulatory issues as well. Finally, we talked about definitions of personal data, and or the personal data is the definition of any information that indicates a living individual. And in GDPR terms, it's been updated to include online identifiers as well. So if you've got things like IP addresses or Twitter handles or other online identifiers that you can use to identify a living individual, then that online identifier is also personal data. And the reason why they've defined that is mainly because the data protection laws previously to GDPR was the Data Protection Directive, and that was from 1995, when a lot of the digital services that we use today didn't even exist. It's worth bearing in mind that, for example, that Google didn't get set up and founded until 1998, so the same time that our Data Protection Act came in as well in the UK. So there's some information about the scope and what's changing with GDPR on that. I've mentioned accountability. This is the 7th data protection principle in GDPR terms, and it's basically a requirement for you as a data controller to demonstrate your compliance. It's not up to somebody to demonstrate you're not compliant. So you need to be able to have to hand any information that will enable you to demonstrate that compliance. There are elements of the regulation, consent's one of them, but there are other elements where you need to record your processing activities as well, and that's under certain circumstances. But in a general sense, it might not be law in the sense of the GDPR telling you to do so, but it makes sense to be able to have some kind of documented record of how you're complying and what you're doing to meet your compliance requirements, purely for the basis of being able to demonstrate your your compliance and meets that accountability principle. So that's quite a significant change when it comes to data protection in general. If you provide online services to children, the information society services are referred to in the regulation, but that basically means any service that's run online, and if it's to be used by children or specifically aimed at children, then if you require consent for the service, then you're going to have to ask for guardian consent as well. So if the user is a child, their guardian, so their parents or carer, needs to be able to give you consent as well. You also need to use child-friendly messaging because they need to understand what it is that you're asking for consent for. And if necessary, you might even have to look at age verification and how you implement that within your service. So the GDPR talks about a child being under 16. In the UK, the GDPR allows member states to derogate away from that if they want to choose a different age, and in the UK, currently there's talk of it being 13. So if you are providing a service aimed at children, then you need to bear that in mind, because there's some things that you will need to pay attention to with regards to data collection and processing. And then one of the big ones that lots of people are talking about, particularly from a marketing point of view, if consent is your lawful basis for processing, remembering what I said about lawful basis for processing, it's about identifying the right one for the circumstances of which you're processing data. But if consent is the lawful basis for processing, typical example, collecting email addresses for potential prospects or cold leads you're gonna, and you want to market to them, you're going to have to seek consent because there would be no other lawful basis for processing. And in that scenario, the rules are changing. You have to have very clear messaging. It has to be clear what it is that you're collecting consent for and what you're going to do with the data and who you are and other aspects about you and the collection of the data. But the idea is that the data subject is clear about what it is that they're about to consent to. And actually, in terms of delivering that consent, they have to positively take an action to opt in. So they not only have to be clear about what it is that you're asking them to consent to, but they actually have to demonstrate it by giving you or taking an affirmative action to give you that consent. What this means in practice is that you'll no longer be able to use pre-tick boxes. So the pre-tick box that says untick this box if you don't wish to be marketed to will no longer exist. You can't use some of the other tricks like double asterisks to take you to a very small print in the terms and conditions somewhere that says you need to tick this box if you don't want to be marketed to, or vice versa. And you can't use any kind of wording that isn't an affirmative action. So you can't say things like, we'll assume it's okay unless you tell us otherwise, because that isn't a positive action by the data subject. You also can't force somebody to give you consent so you can't say to them, well, yes, I can deliver this service to you or provide this product to you, but you have no choice in consenting. That's not allowed. It has to be, as I just said, a very positive action by the data subject. You have to be clear about who you're sharing the data with, how they can withdraw consent, and you also need to honour the withdrawal of that consent. So typically in email marketing terms, you might be using something like MailChimp, and MailChimp's unsubscribe link at the bottom of the email that it puts in by default would, for example, meet the requirements of withdrawing that consent. But in a general sense, consent can be withdrawn at any time in any particular way. So if somebody chooses to ring you up and tell you to withdraw consent, then you need to make note of that and make sure you update your records accordingly. And finally, on the consent aspects of GDPR, you need to be able to demonstrate when consent was given, in what circumstances, where was the data captured, and where do you what was the date and time of the consent that was given. So referring to MailChimp again, in a MailChimp scenario, MailChimp by default, certainly for European businesses, has a double opt-in, which means that the person having filled out their email address on an online form and clicked submit, they will then get an email, and that email will get them to confirm that they really do want to join the list. That double opt-in isn't a requirement of the GDPR, but it sort of rubber stamps your consent and it also within MailChimp has the functionality to record the date and time that somebody consented. So provided you can track where somebody got onto your list from and that you've got the double opt-in in place, then you should be pretty much covered from a consent point of view. Obviously, that's going to be varying depending on what you use to collect your consent in the first place, but that's just an example of where it can work quite well. So that's consent. Individuals have different rights. We talked about data subject access requests as one of the well-known rights. That still exists, but there's some changes. So here's some four specific areas that are either changing or are new. The first thing that's new is there's a right to be informed, which means that at the point that you collect data for whatever purpose, you need to inform the data subject of their rights, who you are, what you're going to do with the data, and so on. And Article 13 of the GDPR specifically lists the things that you need to make available so that the individual can be informed. And those are the kind of things that you'll be putting in your privacy notices on your website or maybe in your terms and conditions. And as I say, Article 13 specifies what to do with regards to the point that you're collecting data for the first time. And Article 14 talks about the same kind of things that you need to notify when you've been given data by a third party. So if you're buying data in from a third party, say for marketing purposes, then you will need to, at some point, at least within a month of having the data, identify yourself and tell the data subject how you happen to have their data and what you're going to do with it and so on. So that's Articles 13 and 14 that cover the right to be informed. Subject access request, as I say, isn't a new individual right, but it is changing. So under Data Protection Act, you can charge £10 plus VAT for the privilege of carrying out a subject access request, and you get 40 days in which to comply and actually respond to the request. Under GDPR, you can no longer charge any fee, and you've got 30 days, so you've got 10 less days in which to deal with the request. So a lot of businesses, if you get lots of subject access requests, would use the £10 as a kind of barrier to sort of limit the number of requests you're having to deal with. And certainly a lot of data subjects think, oh, £10, I'm not paying £10 just to be told something about my data use, and so they'd withdraw their subject access request. That was obviously seen as too much of a barrier, which is why they've introduced a no-fee scenario. So if you are work in a company that does get subject access requests, and quite a lot of them, I'm afraid you're going to be doing them for free going forward, and you have less time in which to deal with them. And then finally, two new ones, the right to erasure and the right to data portability. So the right to erasure, or right to be forgotten, is a data subject's right to tell you that it no longer needs you to process its data, or that the processing you're doing now is unlawful, and therefore they wish you to delete all of their data. This doesn't give the data subject the right to tell you to delete your billing information, so you don't have to be, so you can't charge them. That's not what this is about. This is about removing or deleting data that you no longer need, which you should be doing anyway because of the data protection principle that says you should only retain data for the length of time that you have a business purpose for processing it. So that's the right to be forgotten. And finally, the right to data portability. This is a new right which entitles a data subject to ask you to export their data from in machine-readable format so they can import it into a different system. So the kind of scenario where this is going to be used probably mostly is going to be in switching services. So for example, if you have your electricity supply with Co-op and you wish to transfer to E.ON, as an example, then your portal, when you log into Co-op Energy, will have or need to have a data portability button which will allow you to export the data for your account into a format which you can then import into E.ON's system. And similarly, you know, like changing mobile phones and service providers, that kind of thing. Now, at a baseline, we could all say, well, actually, the answer is comma-separated variable, or CSV files, because most systems understand how to export and import data in CSV format. But the regulation does allow for different business areas to come up with their own common standards and to use those. So if you work in an industry where there is a lot of processing of data and switching of customers, or potential switching for customers, then you might need to keep an eye on any common standards in your industry in terms of what data is exported and how it's imported into your system, and meeting the requirements of those standards. I'm not aware of any in any particular sector at the moment, but as I say, the regulation does allow it. So those are your individuals' rights, or a selection of the ones that are changing or are being introduced. Something else that's changing is the controller-processor relationship. So a data controller, remember, is the organization that's collecting and determining how data is going to be used. A data processor will be a party that will be doing the processing on behalf of the controller. The regulation's changing in a number of ways. So under previous law, with a few exceptions, mainly around security, it was the data controller's responsibility to make sure all processing was being done lawfully, even if they were using a third-party processor, and if something went horribly wrong, it would be the controller that would get into trouble. That still exists and will carry on with GDPR, but processors too have responsibilities and liabilities that they didn't have before. So if a controller is able to demonstrate that they carried out all necessary checks and was sure that the processor was going to be acting lawfully, and it was the processor's fault that something bad happened, then potentially the processor could be found liable, and therefore would have the same kind of liabilities in terms of fines or prosecution as a controller. So that's new. So that's the third in that list. I'm sort of jumping around a bit there. The main thing is that if you use a processor, then you need to carry out due diligence on that processor to ensure that they are GDPR compliant, because you shouldn't be using as a controller, you shouldn't be using a data processor that can't demonstrate their compliance, because you must be compliant in the use of that processor's services. So so you need to be asking your third-party processors what are they doing to ensure that they are GDPR compliant, and then therefore you are maintaining your compliance. And secondly, that needs to be all wrapped up and secured via a legal contractual scenario. So there are legal contractual terms specified in Article 28 of the regulation, which set out specific things that have to be put in place contractually between a data controller and a data processor. Now, if you bear in mind what I said about processing covering everything, it's not just about the use of the data, but also the storage and the manipulation and everything. Well, the storage bit means that if you store your data in a CRM or on a data storage service like Google Drive or Dropbox, then they're all your third-party processors, and therefore you need to carry out due diligence on them, or at least find out what their GDPR position is. And also you need to make sure that contractual terms are in place. Now, depending on where you sit in this, whether you're a data processor or a data controller, how those contractual terms will work will really depend on the relationship you have with your clients. So as from a data controller's point of view, you're carrying out due diligence on your processors and asking them to address the contractual requirements of Article 28. So that's a list of things that need to be put in place contractually, and they vary from things like you won't process my data without my written instructions, right through to we have a right to come and audit you to make sure that you are GDPR compliant. Now, if you're on the other side of the fence and you're a data processor, so you might be a marketing provider and your clients are passing you data to process for marketing, you'll be a data processor, and you can therefore expect your clients to be chasing you for your GDPR statement or your position on GDPR. And asking you to ensure that they're GDPR compliant, and also they'll be pushing on you new contractual terms. And as I was just about to say just a minute ago, obviously how that works will depend on the service. So if you're using Dropbox, for example, you're unlikely to be able to get your lawyers to negotiate contractual terms with Dropbox. What you're more likely to see is Dropbox coming up with some terms of service that meet the legal contractual requirements. So that's Article 28. That's quite a significant change for a lot of people, not least of all because of the way that digital technologies have transformed the way that we use online services. And just reiterating, processing does include storage. So if you are sticking your data in an Excel spreadsheet and sharing it on Dropbox, you're going to have to carry out due diligence on Dropbox. And so you need to think within your business about where you're having your data processed, be it with a third-party company or third-party storage and make sure that you can maintain your compliance with those third-party processors. And just to make things worse, you need to also think about the fact that a lot of these third-party online services, so software services, are US-based. If you're putting data on their servers and their servers are not in the EU because they're stored in the US, then you've got some questions to ask about the international transfer of data outside the EU if it relates to European citizens. So there's quite a lot to think about in this particular area. And I'd say that actually if I was to highlight two key areas where businesses are having to really think about what GDPR means for their business and the changes coming, the first one is consent, which we spoke about just a minute ago, and then this is quite a significant one as well, whether you're a controller or a processor. There's also within GDPR something that sort of existed as best practice in the UK via the Information Commissioner, our regulator, but on the face of the GDPR there is the term of data protection by design and default, and this is a concept where data protection and the privacy of data subjects' data is considered by default in part of any kind of process or approach of processing. What that typically means that if you suddenly come up with a bright new idea about how you can use your customers' data in a way that will enable to help them or help you build your business, you need to make sure that you consider the data protection and privacy ramifications of doing so. So that means you need to make use of tools like data protection impact assessments, DPIA, which enable you to consider data protection at the beginning of a project or the beginning of a development of a new system or service, rather than as an afterthought. So that's data protection by design and default. DPOs, data protection officers. Some businesses are required by law to have a data protection officer, and the regulation, the GDPR, sets out what that data protection officer's duties should be. In a basic sense, it's basically telling the board to not ignore what the data protection officer is telling them they need to do to comply, so they have rights within the business to actually get on and deliver data protection compliance rather than being told to be quiet and sit in the corner and not talk about data protection because it's annoying. So if you are required to have a data protection officer, there's specific things that the DPO is responsible for in terms of compliance, and they're set out in the GDPR regulations. You would need a DPO if you're going to be if you're in a business that's 250 plus employees, you're a public body, and in some other circumstances, and one of those is if the core activity of your business is the regular and systematic monitoring of data subjects on a large scale, then you'll need a data protection officer. Unfortunately, core activity, regular and systematic monitoring, and large scale aren't defined in the regulation, so it's a bit, there's a lot of uncertainty in this particular area. There is some guidance from the Article 29 Working Party about how to interpret those aspects of GDPR, and it's worth taking a look at that, but it doesn't go far enough in terms of real-world examples to really sort of help with a lot of businesses. So if you're an e-commerce site, for example, you can say, well, I'm not large if you compare myself with Amazon, but in your particular area of what you're selling, you might be large compared to some of your competitors, for example. So there's quite a lot to think about if you are regularly and systematically making use of data and processing it. Then you might need to look at whether you need a data protection officer within your business. Right, we're nearly through the 10 breaches. So there's a regulatory requirement under GDPR that under certain circumstances where there's likely to be harm to a data subject, to report the breach to a regulator. So that would be the Information Commissioner's Office in the UK. And if there's a high chance of harm to the data subjects, then you've got to tell the data subjects too. So you're essentially telling the regulator that you've had some problem that's led to the breach of or the unlawful processing of data, where that could be anything from the data being stolen to being unlawfully accessed or shared to being deleted or unlawfully deleted or manipulated. So yes, you need to think about obviously the idea here is that this is a tool to encourage you to make sure you get all the rest of your compliance right, because if not, you're going to have to tell the regulator that your compliance is wrong. And then finally, that sort of takes us really onto fines, which is clearly something a lot of people are scaremongering about, because they're telling everybody and leading with, you know, get this right, otherwise you face these horrible fines. So there's a number of different levels of fines, and in the GDPR, and the top one is 4% of global turnover or 20 million euros, whichever's the largest. But in all reality, we're unlikely to see those kind of level of fines, and you can see that with how things work right now under Data Protection Act. So in the UK, the Information Commissioner can fine up to £500,000 for a breach. If you look at the TalkTalk breach of 2015, when a couple of million user records were stolen and accessed through a system that they were warned wasn't secure, they only got fined 400,000, which is probably the largest that the Information Commissioner has put out, but is also an indication that it wasn't the largest they could have gone for. There's also the example of an NHS trust who shared patient record data with Google's DeepMind AI project with a view to improving patient care by using AI. And when you think about it, Google's a global corporate. The records and the data that's being shared was patient records, which is very sensitive, or special categories of data as classified in GDPR terms. And it was a National Health Trust. You'd have thought that somebody would have got fined, but actually they were able to demonstrate that they'd worked it through, and they'd come to the conclusion, lawyers had had discussions and so on, that actually that it was in everyone's interest to allow the processing of that data, and therefore that was then their lawful basis for processing. The Information Commissioner said they were wrong, but as I say, they didn't actually get fined. They've got some steps that they've got to put in place, and they're being monitored for doing that. But that's another example where you would think a fine would have happened when it didn't, and so that's why I think that you know, the proportionate and the case-by-case approach that the Information Commissioner and actually all the regulators who will need to streamline their approach across Europe will take, which is probably why we'll never see those large fines. And also, it's worth bearing in mind that in UK law, there's also other legal remedies. So status subjects have a right to sue for damages if they feel that they've come to harm through the unlawful processing of data, and you know, company directors, if found complicit in a breach, can be fined themselves or even sent to prison. So there's lots more to it than just fines. So all these people that are scaremongering by leading with fines, you need to sort of see through that and see that there's much more to it than that. So those were the 10 changes that are coming. I've had to rush through those very quickly, running out of time very fast. So I want to try and get some Q&A in at the end. So I'll just work my way through this. So what does compliance look like? Well, if you're coming to GDPR for the first time, then you need to think about how do you prepare your business, and there's no better way than to follow a 5-step plan to basically audit your data and where you need to get to. So first step is really prepare yourself and prepare your business. Make sure the business is willing to support somebody taking action in your business to meet that compliance requirement, and obviously understanding the GDPR is a good place to start. You then need to look at auditing your data, your systems and your policies, come up with a list of data systems and policies, and understand what it is that you've got within your business right now, and then analyze that against where you need to be with your GDPR position. So you need to understand, for example, from a consent perspective, you know, do you have the right level of consent with your existing data, and if not, what are you going to do about getting that consent going forward? And likewise, make sure you update your policies and you address any system changes that might be needed, e.g. the right for data subjects to have data portability functionality if that's relevant. And then that should give you an idea of an action plan that you can then deliver, so that you can meet the 25th of May deadline, and how intensive that will be will obviously depend on how far from GDPR compliance you are, and just how much work you've got ahead of you. One of the key things to do in the delivery phase is also to consider employee training. So if you can train your staff to understand their responsibilities and why data protection is important to your business, then that will help in your compliance. And certainly having this kind of documentation, from the audit to the analysis to the delivery, training your employees, getting policies in place, are all bits of evidence that will help show your accountability when it comes to demonstrating your compliance if needed. And then finally, whenever I talk about pretty much anything to do with GDPR, there's always this concept of ongoing compliance and managing that ongoing compliance, because I'm afraid that data protection isn't a one-off exercise. You don't audit now and then think that's it for another 10 years or 20 years or whatever it is until the Europeans or the UK come up with a new data protection set of rules. You need to make sure you're still compliant. So that's reviewing your policies on a regular basis, making sure your staff get refresher training or at least reminders about what you expect them to do and how they should behave when it comes to data and so on. And that's a very cyclical process that's very ongoing, and is the kind of thing that a data protection officer would be doing within their role. So that's managing security of data, the training, the policies, reviewing, ensuring you're dealing with or applying all the right things in your business to meet the individual's rights requirements. So dealing with subject access requests, for example, do you understand how to do that within your business? So in terms of managing compliance, there's quite a lot to do past the 25th of May 2018. It's not just about getting yourself a big green tick on the 25th of May to say we're GDPR compliant and we're done. It's much more than that. So in terms of things that you can look at, there's 6 listed here of sort of key things to meet your compliance first, if you can, within your business. And if you're a one-man band, that's obviously going to be you, but identify somebody that can take responsibility for your data protection compliance within your business, act as a champion. So you don't have to be called a data protection officer if you're not mandated to have one, but you can call them a data protection officer, a data protection manager, data protection champion, whatever you like. But by having that single point of contact or that single person, they can be the focal point of compliance within your business. And if anybody has any questions, know that they can go to them to help. As I said, consider auditing your business for your data systems and policies to see where you are today and where you need to be with GDPR. Document everything. If you document everything and can provide evidence, then you're meeting the accountability principle and you're able to demonstrate your compliance. You might be in a better position should you be investigated than not being able to demonstrate anything, or that you just ignore data protection. If you can and you have the facilities to do so, provide internal documentation and guidance for your staff so they understand, so your marketing guys understand what they can and can't do with marketing, and so on. And likewise with training, if you deliver training, deliver generic training to everybody within your business so they can understand their responsibilities, understand data protection, their responsibilities, and what the outcomes might be if they breach those responsibilities, then that's going to put you in a better place to maintain your compliance. That sort of goes hands in hand with internal documentation and guidance as well. And you can also educate them to understand who the single point of contact is. And then again, here it is, maintain your compliance and keep up to date. And I'm afraid, in terms of that, and we have already talked about it in the audit cycle, there's actually quite a bit to look forward to and to consider. And so apologies, this is a bit of a downer end to the presentation, but you've got to think about the Data Protection Bill, which is the UK's, the UK Parliament are currently discussing, which implements GDPR into UK law and also addresses some other aspects of it. So you need to understand what that might mean when it gets enacted, probably next year. So we will probably have a Data Protection Act 2018. There's some new e-privacy regulations which could possibly impact consent in terms of marketing consent and marketing compliance. You need to keep an eye on those as well. There's lots of guidance coming out. We're expecting consent guidance from the ICO in its finalized version anytime now, really. And they said it would be before Christmas or in December at least. And there's the Article 29 Working Party, which are the group of European regulators own guidance on how to interpret certain aspects of the GDPR. You've got Brexit to think about. How will data flows affect if you're processing data of European citizens and we leave Europe in 2019? We will be outside the European Economic Area potentially, and therefore that could have ramifications for your business and how you process data. And finally, you've got to think about enforcement. If a regulator in Germany decides to interpret GDPR in a particular way, and it's generally accepted a reasonable approach, then that could impact what's happening in the UK as well. So yeah, apologies for a bit of a negative end to the presentation, because it isn't just about GDPR, it's much wider than that, and it doesn't just stop on the 25th of May 2018 when GDPR comes in. There's quite a lot to think about past that, particularly in UK with Brexit happening. But don't worry, there's lots of help around. The Information Commissioner has a decent website that gives you a certain level of help and support. But of course, and here's the sales pitch, I run a service called Digital Compliance Hub, which is an online subscription service which can give you help and guidance, toolkits, as well as a support line to cover not just data protection and GDPR, but also privacy and marketing compliance, as well as web and data security. So you can try it for 14 days for free. Just go to digitalcompliancehub.co.uk to have a look at that. And if that's not your thing and you need some very specific help, then my consultancy can offer GDPR audits. So that's carrying out that audit cycle that we talked about, as well as ongoing management and compliance, as well as consultancy by the hour and advice and training as well. So there's a lot to that I can help you with, and it doesn't matter whether you're looking for a small project or something very significant. Then there's something that we can probably do to help you with that. Which brings us to the question area, or the question section. So if you've got a question, I don't know if anybody's been typing away while I've been talking. If you've got some questions, then feel free to type those in the questions section. Nothing's come through so far, and we'll try and answer them. We've got about 5 minutes to get through any questions. Okay, well, that seems uncharacteristically quiet, because normally people have got lots of questions, but that's feel free to type those in now. If not, if you think of something you wish you'd ask, then by all means ping me an email. But if that's that, then I'm happy to leave it at that, and I hope that was useful. Okay, well, nothing's come through, so thank you very much for joining. I'll circulate a recording of the presentation, so you can revisit that, and yeah, I hope that was helpful. Enjoy the rest of the day, and have a great Christmas break. Thanks.